Everyone keep your seats, come back to order. Keep your seats, go to order.
My additional thing, Mr. Gross. Under the premise that we all understand what we're doing here, but I need to make sure that the Attorney General and the appellate courts do later. We've had a couple of arguments where we've talked about the potential need for us to object. We're aware of all of that. Your Honor's also cautioned us about, not being interrupting more than necessary. So we will object and reference prior arguments as the code for incorporating these earlier discussions by reference. And also in that same vein, I think it's incumbent on me to renew our request for a final argument, or in the alternative request that they open and full on the law and the facts, and only be allowed to reply to the matter.
Very good. That's how we will handle it. Your request your request concerning the order of the final argument is further earlier ruling that the request will be denied. Let us have the jury, please. When they come out, Mr. President, you rest formally on the record, then we'll go back.
And then everything is incorporated with that.
It is. Yes, you do not need to renew your motions at that particular point in time. They have been renewed. You've already rested formally on the record, so you are effective on all motions.
All yours, Brother Chuck.
Ladies and gentlemen, the jury, first of all, sorry for keeping you waiting back there. I can explain that momentarily. I do, above all, hope that you had a pleasant evening last night. Again, I'm sorry for keeping you waiting in excess of 2.5 hours. I know that you were there on time, and I appreciate that. So you got my apologies if you've been bored back there. We are resuming with the trial of the case versus the state versus Mr. Brown. And at this point in time, Mr. Gross.
Thank you, Your Honor. At this time, we would exercise our right not to present a case and rest.
Very good. Ladies and gentlemen, the jury, at this point in the case, you've received all the evidence that you're going to have in order to judge this case, and now the attorneys will be given an opportunity to give you a closing argument or a closing summation. I'll remind you that what the attorneys say during their closing argument is not evidence, okay? It is merely their contention as to what has been proven or has not been proven. You have to judge this case based on the evidence and the exhibits which have been introduced into the record, as well as any stipulations. So if at any point in time, ladies and gentlemen, the lawyers make a comment about the facts or the testimony, what have you, and their comment about those facts differs from what you were calling the facts being, the testimony being, you, of course, should go with your recollection of the facts because you are the judges of the facts in this case. For example, if the attorneys were to say that on Monday it was cloudy, rainy, miserable, wet, cold weather, and yet you remember Monday being a fairly sunny, pleasant, perhaps a bit warm day, you should go with what your recollection is as opposed to what they say the weather was like on Monday. I've instructed the attorneys that they have 30 minutes total for closing argument. The order that we will use is that the state will go first. They'll open briefly on the law to be followed by the defense, and then the state will have the opportunity to speak to you one last time. Mr. Bentley will be serving as the official timekeeper, and he'll relate. I'll keep time on the stopwatch, and he will relate to the attorneys by way of a legal pad when you have 10 minutes, 5 minutes, and 1 minute, okay? With that, Solicitor, you are recognized for your closing of the lawsuit.
Thank you, please.
Yes, sir.
A thought occurred to me yesterday afternoon, as all of us had the opportunity to go to 545 Barrelstone Road, and as we had an opportunity to walk the property, a thought occurred to me that hadn't come to me before, and that it was this. And I didn't even think about this before we went out there. But that yard that we were walking in is hallowed ground. It's hallowed ground because of this, because a man, an officer of the peace, a good man, a man with a family, a man with friends, a man with a wife and children, a man that served this community in Lawrence County, that property we were walking yesterday is the place where he gave the last full measure of devotion to this county. The last full measure of devotion, and it left a massive hole. It left a massive hole in the life of Stacy Rice's wife. It left a massive hole in the lives of his two children, Christian and
Prior
Austin.
motion, Sean.
It left a massive...
Solicitor, you need to define, this is supposed to be the opening of the law, though.
That's correct. And I'm about to get into that.
Very good.
It left a massive hole.
I'm sorry, Judge, I thought you sustained that.
The objection is overruled because he's about to get into it right now. And
Thank
I'll
you.
add some time to your time, Solicitor.
It left a hole in the lives of a lot of the officers y'all heard testify on this witness stand this week. But it wasn't just that. He also left a hole in the lives of his own family. Brutally taking the life of Peaches Kingsmore, mother of his children. 2 lives, 2 bullets. These 2 bullets right here, as you go back to the jury room with you, shot from one gun from his hand, is .357. In less than an hour, completely wrecked and destroyed 2 families. Now, as Mr. Scott told you in the beginning, we're the state, only in America, is one of the greatest justice systems that's ever been devised because a defendant, here Benny Brown, a man who wrecked 2 lives that night, can come into court and ask for a jury trial. And that's what we're doing here this week. And so the burden is entirely on Mr. Scott, Mr. Andrews, Mr. Bentley, and I to prove to you. So that's what we've been going through the last few days. That's our burden. And that's a burden, folks, that we gladly bear. We don't apologize for it. We don't back up from it. Because the evidence is so overwhelming in this case. We gladly bear it. Now, what is the burden of proof? I'm going to go through a few PowerPoint slides here. The judge is going to instruct you on the law at the end of this case. But I'd like for us to go through a few of these. Talk about what the burden is. The burden is beyond a reasonable doubt. What the judge is going to tell you, I want to listen for 2 words in his charge. You're going to hear it said, I believe 2 or 3 times, that this is what the burden of beyond a reasonable doubt is. In each element, we firmly convince you of the guilt of the defendant as to each element of the case. Firmly convinced. That's not some crazy scientific formula. It's not a mathematical equation. This is a very simple concept in the law that after you've heard all the evidence, you've seen the evidence, you've heard the witnesses from the stand, that you are firmly convinced at your core that the defendant's guilty of what he's been charged. So I want you to listen, but firmly convinced when the judge instructs you on what the burden of proof is in this case. Now, what do we have to firmly convince you of? Murder in the state of South Carolina is essentially 2 elements. First element is a homicide. It's a killing of another person. That's simple enough to understand. And this is where it gets a little more complicated, probably words you don't hear every day, with malice and forethought, either expressed or implied. Probably don't hear the terms malice and a forethought every day. It's the terms that our legislature used when they put this into laws. That's what murder is in our state. Let's unpack a little bit what malice is. The judge is going to tell you that malice is the intentional doing of a wrongful act without just cause or excuse and with the intent to inflict an injury. So he's going to tell you that it is an intentional act. That's one way you can prove malice is intent, express intent. Someone saying, I'm going to kill someone. Or their actions show their express intent to kill the person that they're, for example, pointing a gun at. Ladies and gentlemen, I would submit to you that the homicide of Peaches Kingsmore, this is States 15, you'll have this in the jury room. There's a dowel rod that shows exactly, or very closely, what Benny Brown did when he came up to the window, took that .357, pointed it in the where the window was open, and put a bullet directly in Peach's head. That is express malice, folks. And that is intentional doing of a wrongful act without just cause or excuse. That's malice, that's murder. Murder can also be implied. So it's not just express murder, but implied murder. There again, express malice would be a deliberate intention, a specific intention to kill another person, unlawfully. Implied malice talks about circumstances. You're going to hear the judge talk about circumstances would show you that you could imply that there was an intention. And this is the type of circumstances that would demonstrate this extreme disregard for the life of another human being. I would say that's the type of malice that could also be at play in the killing of Roger Rice. Doctrine of transferred intent, this is a very simple concept, folks. I don't want to spend too much time on this, but it's when a defendant has expressed malice towards another person, intention to kill. That intention, if someone else gets hit by the bullet, that malice follows the bullet. That's what the judge is going to take. So if there's an intent to kill one person and malice as to one person, and another person is struck and killed, under our law, that says you're guilty of murder of the person that was hit. Okay? So that's the doctrine of transferred intent. You have malice towards one person, shoot a gun with reckless disregard for the lives of others, and the bullet hits another human being. That is murder, and it's implied malice. Or it could be expressed. It could be an express intent to shoot one person, the bullet misses and hits somebody else. This is simple too. Possession of a weapon at the commission of a violent crime. This will be one of the indictments for your consideration. Possessing a weapon during the commission of a murder or an attempted murder is guilt under our law. So that's a very, if you find Benny Brown was guilty of murder, an attempted murder, and that he possessed that .357 when he did it, and he's guilty of that. It'll be one of the simplest decisions you make in this process. Now, attempted murder, what the judge is going to instruct you on, we already went through malice, is that attempted murder is attempting to kill another person with specific intent, and also implied in that it's either express or implied malice. So there again, you're going to import the concepts that we just talked about of malice with the attempted murder charges, and there's 5 of those. And I would submit to you, ladies and gentlemen, that there could be transfer of intent involved with that, potentially. I would also submit to you on these facts that you could reasonably infer malice from his disregard for anybody else's life that was in that yard when he came out shooting, including Rico Kingsborough, but also the 4 officers we heard testify. And those are the other attempted murder charges. Shane Creighton. We have Eric Robinson. We have Casey Jones. And we have Lieutenant Robert Plaxico. And those are the other 4 attempted murder charges. So if there's malice, intent to kill, when he comes out that door, then you can find him guilty on those charges as well. You're also going to hear about self-defense in this case, folks. I want to spend a little bit of time on this. If a person acts in self-defense under our law, obviously that would be a justifiable homicide, correct? And I'm sure you're going to hear about some of this from the defense. But the first element of self-defense under our law, and I want you all to pay attention to this and read this. The defendant must be without fault in bringing on the difficulty. And so you're going to hear from the defense attorneys in a little bit that, well, Benny's not guilty of killing Roger Rice because he was just acting in self-defense. Or he was acting in defense of his cousin, Benny Brown, out in the yard. He somehow magically broke away from his homicidal and suicidal thoughts. And all of a sudden he's going to be acting in self-defense or the defense of others. But here's the one element that must be shown to establish self-defense. The defendant must be without fault. Folks, why was it like that? Law enforcement were there, family members were there, because he had just killed his wife in cold blood right up the road in Fountain Inn. He had called his family members and said, I did it. Now I'm going to kill myself. That's why everyone was there. And so Benny Brown was at fault that night, folks. And that's a non-starter for a self-defense. So I want you to remember that as you listen to the rest of the argument. Of course, the other elements are about imminent danger. The defendant has to think he was in some kind of imminent danger, or have been in imminent danger. Well, Benny Brown was in his house behind brick walls, and we'll talk a little bit more about in a minute about what the situation in the yard was right before he came out and shot when I get up my second time. But folks, I would submit to you that it's laughable to say that Benny Brown was in any imminent danger himself inside that house. And you have to believe a fantasy and a fiction to believe that he had any kind of intent to protect people in the yard. And we'll talk more about that later as well. This is not a self-defense case, folks. And it's almost insulting that the defense would try to sell you a bill of goods that these elements...
Objection. Improper argument. Move to strike. Request curative instruction.
This is not a self-defense case, folks. You've seen the evidence. We're going to talk a little bit more about that. But remember that when you hear Mr. Frost argue. We're going to talk a little bit about this more in a second, too. When we talk about intent, Benny's statement in the back of the ambulance, he meant to F her up, talking about it in law. Intent to kill. And what was he doing, folks? Right before he opened that door and looked out and saw a police car, blue lights bouncing everywhere, what was in his mind? I'm not sure. But I can tell you, you can rely on at least his statement in the back of the ambulance that you saw Lieutenant Goggins take. I'm going to F her up. He's talking about a family member. He's talking about intent when he comes out of that door. Folks, we're going to talk a little bit more after the defense has an opportunity to speak with you. I want you to remember as you listen to their argument that this is not a complicated case. This is a case about malice. This is a case about murder. I look forward to speaking with you.